So the state of New York's concealed carry law, which defied the Supreme Court's ruling in Bruen, was just struck down. So let's talk about this. But real quick before we jump into this video, if you agree that the New York concealed carry law is unconstitutional, go ahead and hit the like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, the state of New York's new concealed carry law has been struck down by a federal court who granted a temporary restraining order against various aspects of that new CCIA law. The case we're going to be talking about in this video is Antioch v. Bruen, and this was a GOA case which was refiled after the same federal court judge dismissed the prior case for a lack of standing. If you don't recall, GOA sued New York because of the new concealed carry law, which was passed and went into effect in the state of New York and was done in direct defiance to the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. In Bruen, the Supreme Court struck down the New York may issue concealed carry scheme, finding that it was inconsistent with this nation's history and tradition. However, despite that decision by the Supreme Court, New York decided to rush through a new law called the Concealed Carry Improvement Act, or the CCIA. Instead of rolling back their concealed carry laws in accordance with what the Supreme Court said, the state decided to double down on all of their gun control provisions and create a concealed carry scheme that was even worse than the one that existed prior to Bruen. Because of how this law directly violated the Supreme Court and the Second Amendment in that decision in Bruen, GOA, Gun Owners of America, decided to file a lawsuit against the state of New York. In the original lawsuit, Antioch v. Bruen, GOA asked the district court judge, Judge Sotheby, for a preliminary injunction against the enforcement of the law. However, in response to that original lawsuit, Judge Sotheby decided to dismiss the entire case based on what he believed was a lack of standing. And because he dismissed the entire case because of a lack of standing, the New York concealed carry law was allowed to go into effect. However, in that same order dismissing the case, he did run through an analysis stating that if he could rule on the merits of the preliminary injunction, he would find that the state of New York did violate the Constitution, did violate the Second Amendment, and that this concealed carry law in the state of New York was not in adherence with the Supreme Court's ruling in Bruen, and that he would find it invalid. And what GOA decided to do was to refile the case and to try to fix all those standing issues. And then also, after refiling the case, they sought a temporary restraining order and a preliminary injunction against the state of New York to stop the enforcement of this new concealed carry law. And the important update I have for you in this case, and the big news in this case, is that today the court, the judge here, Judge Sotheby, did grant the TRO against the state of New York. So let's go through some of the aspects of what the judge is restraining in regards to this specific law in the state of New York, and kind of the things that happened through the granting of this temporary restraining order. So first, the judge found that the good moral character standard was invalid. One of the primary reasons the judge found that the standard was invalid is because he stated under Bruen, the Supreme Court endorsed a standard that compels a state to issue a carry license unless the licensing officer finds that the applicant is likely to use a handgun in a way that is a danger to himself or others. Essentially, the Supreme Court established a baseline of shall issue, and that the shall issue permit should be the baseline, which would be that the state of New York would have to do that through an objective standard. Judge Sotheby states that instead the CCIA expressly prohibits the issuance of a license unless the licensing officer finds that the applicant is of good moral character, which involves undefined assessments of temperament, judgment, and trust. He essentially stated that the burden of showing a good moral character standard is akin to the special need for self-protection distinguishable from the general community, which the Supreme Court just struck down in the Bruen decision. Then Judge Sotheby says that, simply stated, instead of moving toward becoming a shall issue jurisdiction, New York State has further entrenched itself as a shall not issue jurisdiction, and by doing so, it has further reduced a first-class constitutional right to bear arms in public for self-defense into a mere request. And because of that, he granted a TRO against the good moral character standard, which was included in the new concealed carry law of New York. Then the judge looked at other aspects of the CCIA. He went in and enjoined the enforcement of the law requiring that the applicant provide a list of family members and cohabitants. He also looked at the personal, in-person meeting requirement and found that that was not in the text, history, or tradition of the Second Amendment. There was no historical basis for that to require in-person meetings for an applicant, and therefore he enjoined those specific aspects. He enjoined the in-person meeting, and he also enjoined the cohabitant family member list requirement. Then he looked at the sensitive places restriction that the state of New York had put in place with this new law. The court ultimately found first that the federal and state building requirements and the polling place requirements, those restrictions, he found that there was likely an analogous restriction, that there was probably some sort of history or tradition in prohibiting carrying in those locations. And also he pointed out that the Supreme Court in Heller and Bruen also mentioned that those could be sensitive places. Therefore, he did not enjoin the effect of the law against those locations. Then the court also looked at churches and looked at historical references to banning concealed carry at churches, and found that essentially under some circumstances, those could be treated as sensitive locations. And also he looked at schools, colleges, universities, and also found that those could likely be treated as sensitive locations. However, he then looked at public transportation, and he found that there was actually no historical analogs, no historical basis, and he could find no evidence at all to support a ban on carry in those types of locations, on transportation, subways, etc. Then the judge looked at the ban on carry in places of entertainment and also places that served alcohol. On review of the history and the tradition surrounding this type of restriction, the judge found that there was little support for this type of carry ban, and therefore ordered that that aspect also be temporarily enjoined. He then did the same thing with Times Square. He looked at the history and tradition surrounding a ban on concealed carry at Times Square, and he found that there was no historical support for that type of ban. Therefore, he restrained that aspect of the law. And lastly, he looked at the catch-all provisions of the CCIA, which essentially banned concealed carry in all locations unless the business or property owner gave express consent to concealed carry. The court looked at the historical statutes being used by New York to support this provision of the law, and ultimately the judge found that these laws were in place only for enclosed farmlands and hunting grounds, and the ultimate goal of those laws, which the state of New York was putting forward, was the historical basis for those was essentially to prevent poaching. And ultimately the court found is that those laws do not support an outright ban on concealed carry in all locations unless there is express consent given by the business or the property owner. Therefore, the judge enjoined the catch-all provision of the New York law. So after going through the CCIA, the judge temporarily restrained various aspects of the application process and also the sensitive location restrictions. Some important aspects that were allowed to remain in place included the 4-person reference letter requirement that is included in the law, and also the 8-hour training requirement for someone to get their concealed carry permit. There were also some sensitive locations that the judge agreed could be considered to be sensitive places, including traditional government buildings, federal buildings, polling places, and schools as well. However, there were a ton of solid wins that actually came out of this judgment, and I would say that overall this was a very positive decision by this judge. The judge restrained the whole good moral character standard, which was a big win. He shot down the whole social media requirement. He shot down the in-person meeting requirement for the application process, and also shot down the whole list of family members requirement that was also required for the application process. He also shot down and restrained most of the sensitive location restrictions, including Times Square, subways, public transportations, anywhere that serves alcohol, and also all those catch-all provisions. They were all essentially shot down under this judgment. Now, there is a caveat to all this that I want to point out. In the same order, the judge issued a temporary stay on his own judgment. The stay is going to be in place for 3 days, which gives the state of New York the time to appeal and seek an emergency relief from the Second Circuit. I think we can all agree that the state of New York will likely seek that appeal. They will seek emergency relief. They've already indicated that they will. And the question now becomes whether or not the Second Circuit is going to grant that emergency relief. I would lean more towards yes, they will do it. But right now, I just want you to know that the effect of this judgment is not in place yet. It stayed for 3 days. But I would suspect that the Second Circuit here will also further stay the effect of this judgment, and they will likely take into appeal or grant some sort of emergency relief. So just suspect that that's coming. That's traditionally what happens. But overall, this was still a good win. So we will definitely be keeping our eyes on this case to see what happens. If I get any more information, I will definitely update you guys and let you know. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and like support the channel, and the best way to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel algorithm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.